This is Barry Zalma on insurance. Today I'd like to speak about some grounds for denying a claim, starting with the misrepresentation or concealment of a material fact. To constitute fraud, an insured must have concealed or misrepresented a material fact with the intention of inducing an insurer to pay a claim it would not otherwise owe had it known the true facts. The facts that are deemed to be material for purposes of denying a claim or voiding a policy are not clearly defined, and therefore each case must be evaluated separately. Generally, a fact is material to the application for insurance if it might have influenced a reasonable insurer in deciding whether to accept or reject the risk on the same terms and conditions. Material facts intentionally concealed or misrepresented with intent to mislead the insurer that result in damage to the insurer are, by definition, fraudulent. Fraud, at the option of the insurer, allows the insurer to void the policy. A misrepresentation after a loss, as to a single material fact, will forfeit the entire insurance contract. An insured cannot commit a small fraud any more than he can be just a little bit dead. Once caught in a small fraud, the insured cannot demand that he or she be paid the legitimate part of the claim and expect the insurer to forgive the attempted fraud. Determining the existence of a misrepresentation is not always straightforward. In Suggs v. State Farm Fire and Casualty, a 1987 decision of the 10th Circuit Court of Appeal, an initial investigation by an insurer and the state fire marshal concluded that a residential fire was the result of arson. The fire marshal further concluded that it was the insured who set the fire. The insured was arrested and charged with fraud. With criminal charges pending, the insured hired experts who concluded that the fire was probably caused by an electrical malfunction. Criminal proceedings were then dismissed. Another expert retained by the insurer later concluded that the fire was not of electrical origin, and the insurer denied the insured's fire damage claim on the ground that the insured had intentionally set the fire. The insured responded by suing for benefits under the policy as well as for tort damages under the tort of bad faith. A jury found in favor of the insured on both causes of action. In my personal experience, an insured who did set fire and caused an arson fire to occur made it look like it was of electrical origin by having the point of origin at an electrical transformer. However, my investigator found that at the time the fire occurred, all of the electrical power to the facility had been turned off, and therefore it could not have been an electrical fire because there was no electricity flowing to that transformer. It depends on a thorough investigation whether or not there are grounds for denial. The State Farm case was found to be wrong. My case was found to be right. On appeal, the 10th Circuit reversed the bad faith judgment for State Farm. The termination of the arson prosecution was found to be immaterial because the disposition of criminal cases requires different criteria than civil cases. In any event, substantially conflicting evidence existed regarding the nature of the fire. Based on this conflict, the Suggs court held that the only reasonable conclusion the jury could have reached was that the insurer had not acted in bad faith. It was just wrong. The insurer had good reason to believe that the insured Suggs misrepresented facts material to the claim by denying he set the fire. The insurer was unable to convince the jury, however, that the insured lied, but was able to convince the 10th Circuit Court of Appeal that the denial was made in good faith. This is the key to every denial, that it be made in good faith, that there is sufficient evidence to establish that a ground existed for the denial. It might be wrong, but if it's made in good faith, the worst that could happen is that the insured would be required to receive only the benefits promised by the policy. Although the Suggs case resulted in a beneficial or partially beneficial verdict on behalf of the insurer, it revealed the need to deal fairly in good faith with all insureds, and even more so with insureds suspected of fraud. If the insurer treats the suspected fraud with the utmost of good faith, it will avoid unnecessary litigation, will have sufficient facts to deny a claim, and will explain to the insured all of the reasons for the denial. Now, when an insured misrepresents or conceals a material fact in an application, some states, like California and New York, find that when the misrepresentations as to material facts made in an application for insurance exist, there is a fraudulent intent to deceive, is not essential to the avoidance of the policy. Even an innocent misrepresentation or a concealment made mistakenly is sufficient if the insurer is deceived and if the policy is thereafter declared void. In these states, applying what has been called the Marine Rule, a policy can be rescinded for an innocent misrepresentation or concealment of material fact. In the presentation of a claim, however, the Insured's Act must have been intended to defraud the insurer. Even a gross overvaluation of a claim will not permit an insurer to deny the entire claim or declare the policy void unless the insurer can prove that the overvaluation was not an honest mistake, but was an intentional fraud. Courts in different states have difficulty with the concept of fraud and fraudulent intent. In Auto Owners Insurance Company versus Hanson Housing, a 2000 decision of the South Dakota Supreme Court, that court confirmed that exaggerated claims for the purpose of gaining an advantage in settlement negotiations are considered attempts to defraud, even if the insureds do not expect to ultimately obtain more than their actual loss. On the other hand, that court recognizes that there may be an honest misstatement of some fact, and that although, as a general rule, fraud and false swearing will void the policy, mere mistakes in stating facts that do not in themselves annul its conditions do not appear to be willful misrepresentations and will not defeat the action. It is up to the jury, with instructions from the court, to determine whether the misrepresentation is a mere mistake or an intentional attempt to deceive. The insurer can prove reliance in the application process by showing that it issued a policy based on the insured's fraud that it would not otherwise have issued. Under New York's penal law, section 176.05(1), a fraudulent insurance act consists of a presentation with fraudulent intent of a false written statement in connection with a policy for either commercial or personal insurance. When plaintiffs argued that the trial court erred in granting defendant summary disposition because a question of fact existed concerning whether the statement at issue in the application was made in good faith and without fraudulent intent, a Michigan Court of Appeal concluded it is unnecessary for an insurer to show fraudulent intent in order to cancel an insurance policy where the applicant makes a material misstatement concerning his prior medical history. Fraudulent intent is rarely susceptible to direct proof and must ordinarily be established by circumstantial evidence and the legitimate inference arising therefrom. An inference of fraudulent intent can be established by a showing of a motive for committing fraud or by identifying conscious behavior of the accused party. Materiality of false statements is determined by the result it would have on the insurer, its underwriter, or claims person. Materiality is not determined by whether or not the statements deal with a subject later determined to be unimportant. If, for example, false statements are made about factors other than those that caused a loss, the false statements are nevertheless material. Falsely sworn statements are always material. False statements are material if they might have affected the attitude and action of the insurer. They are equally material if they were calculated to discourage, mislead, or deflect the company's investigation in an area that is at all relevant to a claim. A fact is material to a claim if it concerns a subject relevant and germane to the insurer's investigation of the claim. Based on the evidence, an insurer presented a reasonable jury might conclude that the person seeking benefits from the insurer acted with fraudulent intent. Courts have regularly held that a medical professional's financial motive to obtain no-fault insurance benefits by making intentional misrepresentations to an insurance company is sufficient to demonstrate scienter or evil intent. The term material means having a natural tendency to influence or be capable of influencing the payment or receipt of money or property. This materiality requirement descends from common law antecedents. The common law would not have conceived of fraud without proof of materiality. Therefore, before an insurer decides to deny a claim, it must have conducted a thorough investigation that establishes beyond a preponderance of all evidence that the claim is one that is not covered by the policy. In addition, if the claim includes evidence of fraud, it is essential that there is strong evidence sufficient to require the insurer to report to the state the suspicion that a fraud is being attempted or has succeeded, and is sufficient to determine that the policy is void as a result of the fraud. This video was adapted from my book Selma on Insurance Claims, Part 110, 3rd edition, and is available as a Kindle book, a paperback, or a hardcover from Amazon.com. If you found this video to be useful or interesting to your colleagues, please pass it on. It's free. And please also subscribe to my YouTube channel and my Rumble channel, clicking on the like and Rumble buttons as you do. And please subscribe to my blog, my Substack publications, and my locals community, so that you can be advised of future videos and future blog postings. Thank you for your attention.